My husband died 10 years ago, but yesterday I received a letter from him in the mail. The postmark date, yesterday, inside one line, "Don't trust your son, check the basement." My hands trembled as I went downstairs and saw, "Good day, dear listeners. My name is Martha Calloway, and I want to tell you about the year I learned that love can be used as a weapon and that the dead sometimes speak louder than the living. For most of my life, I considered myself a lucky woman. Harold and I built our home in Millbrook, Ohio, back in 1978, a two-story colonial with a wide porch and a basement Harold used as his workshop. We raised 2 children there. Our daughter Pam, who moved to Portland and called every Sunday without fail, and our son Derek, who stayed close. Harold passed 10 years ago, a heart attack, sudden and merciless, on a Tuesday morning in October. I found him in the kitchen, still holding his coffee mug. That image never fully left me, but I survived the way women of my generation learned to survive, quietly, stubbornly, one day at a time. I was 68 years old, living alone in that house, and for the most part I was fine. I had my garden. I had my neighbor Ruth, who brought me tomatoes from her greenhouse and stayed for tea. I had my church group on Thursdays. And I had Derek, who lived 20 minutes away and came by every week or two. He was attentive. Too attentive, I would later understand, but at the time I told myself I was fortunate to have a son who cared. The first sign I dismissed was small. Last spring, Derek began asking questions about the house. Casual questions, the kind you might ask over a piece of pie. "Mom, do you ever think about downsizing? This place is a lot to maintain." I told him I managed fine. He smiled and dropped it. But he came back to it 2 weeks later, this time mentioning a lovely senior community in Dayton, "just to look at," he said. No pressure, I changed the subject. The second sign was harder to ignore. I noticed paperwork on the kitchen table. I hadn't left it there, a manila folder just sitting near the fruit bowl as though it belonged. When I opened it, I found some kind of property valuation form with our address printed at the top. Derek's handwriting was in the margin. I asked him about it the next time he visited. He laughed it off. "Oh, that's nothing, Mom. Just something I was looking into for tax purposes. Don't worry about it." I put the folder in the drawer and tried not to think about it, but I did think about it. I thought about it a great deal. The third sign came from Carla, Derek's wife. She had always been polished and pleasant in the careful way of someone performing pleasantness rather than feeling it. But that April, she began accompanying Derek on every visit, and something in her manner had shifted. She watched me, not rudely, nothing you could point to, but with the quiet attention of a woman calculating. She complimented my jewelry twice. She asked whether I had an updated will. She said it with a warm smile. "It's just smart planning, Martha. Harold would have wanted you to be prepared." I nodded and excused myself to the kitchen. My hands were cold. I told myself I was being paranoid. Derek was my son, Harold's son. A man I had rocked to sleep, driven to baseball practice, sat beside in the hospital when he had his appendix out at 14. What kind of mother suspects her own child? And then the letter arrived. It was an ordinary Thursday. I had just come back from the church group, still wearing my cardigan, when I found the envelope in the mailbox. My name was written on the front in handwriting I recognized before I even fully processed what I was seeing. Harold's handwriting. My heart did something strange, not quite a lurch, more like a skipped beat, like a record scratching. I stood on the porch and looked at that envelope for a long time. The postmark was yesterday's date. The return address was a law office in Columbus, Whitmore and Associates. A name I didn't know. Inside was a single index card, 5 words. In Harold's unmistakable blocky print, "Don't trust Derek. Check the basement." My hands were shaking so badly I had to sit down on the porch steps. The cardigan suddenly wasn't warm enough. I sat there for several minutes listening to the neighborhood, a lawn mower somewhere, a dog barking twice and going quiet, and I tried to make my mind work. Harold had been dead for 10 years, and yet here was his handwriting telling me not to trust our son. I went inside. I stood at the top of the basement stairs for what felt like a very long time. Then I turned on the light, held the railing with both hands, and walked down. What I saw stopped me on the 3rd step. The workshop, Harold's workshop, which I had not touched since he died, had been cleared out. The tools were gone. The workbench was covered with stacked papers, binders, and a laptop computer I didn't recognize. On the wall where Harold used to hang his levels and squares, there was a whiteboard with names, numbers, and arrows drawn between them. My name was at the top. There was a box on the floor, open, stuffed with what looked like legal documents. I could see the words power of attorney printed in bold letters on the top page. I did not go further into the room. I walked back upstairs, sat down at the kitchen table, and pressed my palms flat against the wood to stop the trembling. Something was happening in my house, something had been happening for a long time, and Harold, somehow impossibly from 10 years in the past, had just told me to look. I didn't sleep that night. I sat in the armchair by the bedroom window, the one Harold used to read in, and I went over what I knew, the way you sort mail, slowly, carefully, setting things into piles. The folder on the kitchen table. Carla's questions about the will, Derek's talk of senior communities, the cleared-out basement, the binders, the whiteboard, the words power of attorney on a page that had no business being in my house. By 3 in the morning, the fear had done what fear sometimes does when you sit with it long enough. It turned into something harder, colder, anger, yes, but more than anger, clarity. Whatever Derek and Carla were planning, they had not done it yet. The paperwork was still downstairs, no documents had been signed, none that I knew of. The house was still mine, my mind was still mine. I had not been declared incompetent, I had not agreed to anything, which meant there was still time. The question was what exactly I was dealing with. The following morning I went back downstairs, this time all the way in. I did not touch anything. I had watched enough television to know that you don't disturb evidence before you understand what it is. I stood in the middle of the room and looked carefully. On the workbench were 3 binders labeled by year, 2022, 2023, 2024. The laptop was closed. The open box sat beside them. I leaned over and read what I could without picking anything up. There were multiple copies of something called a voluntary conservatorship agreement, a document by which a person agrees to transfer management of their finances and property to another party. My name was on these forms, pre-filled, in a font that had been designed to look like a signature field. There was also what appeared to be a medical letter. I could see the letterhead of a doctor I had never heard of describing a patient with mild cognitive decline and early-stage memory impairment. The patient's name was Martha Calloway. I had to grip the edge of the workbench. Someone had fabricated a medical record. Someone had prepared conservatorship documents. And the documents were here in my house, in my dead husband's workshop, waiting to be used. I went back upstairs and made coffee, not because I wanted coffee, but because I needed something to do with my hands. I thought about calling Derek. I thought about it seriously. The mother in me kept insisting there must be an explanation, that I was misreading something, that a conversation would clear this up. But then I thought of Carla watching me. Of the property valuation form, of Derek's easy laugh when I asked him about it. Don't worry about it, Mom. No, if I called him now, they would know I had been in the basement. The documents would disappear. And then it would be my word against theirs, a 68-year-old widow against her son, against papers that no longer existed. I needed evidence first, real evidence, and I needed someone I could trust. That afternoon, I called Pam. My daughter answered on the second ring, cheerful and rushed the way she always was. But when I said, "Pamela, I need you to listen to me very carefully," she went quiet. I told her everything, the letter, the basement, the documents. I heard her breathing change. "Mom," she said, "don't touch anything down there. Don't tell Derek you know I'm getting on a flight." "You don't need to, I'm getting on a flight," she repeated. Tomorrow morning, after I hung up, I felt something loosen slightly in my chest. Not relief, not yet, but the particular comfort of not being alone. Still, I did not wait for Pam to take my first step. That evening, I went to my writing desk and found Harold's letter again. I read it once more. Don't trust Derek, check the basement. The card was cream-colored, the ink slightly faded, old ink, not new. Harold had written this a long time ago, which meant he had known something or feared something. And he had arranged, through that law office in Columbus, for the letter to reach me under some specific condition. I needed to find out what that condition was. I went to my computer and searched for Whitmore and Associates in Columbus. The firm existed. It had a modest but professional website specializing in estate planning and elder law. I wrote down the address and phone number on a notepad the way I used to write grocery lists, deliberately pressing the pen firmly into the paper, as though making the information more real. My plan at that point was simple. 3 steps: speak to whoever at Whitmore and Associates had sent the letter and find out what Harold had left behind. Document everything in the basement before Derek had any reason to move it. Speak to a lawyer of my own lawyer, not Harold's estate attorney, someone entirely new about what voluntary conservatorship meant legally and what could be done to block it. I was not going to confront Derek. Not yet. Confrontation without ammunition is just noise. I locked the basement door, then I put the key in my cardigan pocket. After that, I sat down and ate supper, soup from a can, nothing special. Because I had read somewhere that you think more clearly when you've eaten, and I needed to think very clearly. Outside, the evening was quiet. The porch light was on as it always was. The neighborhood looked exactly as it always had. But I knew now that inside this ordinary house something had been growing for a long time in the dark, and I had only just found the light switch. Pam arrived the next morning on the 7:15 flight from Portland. I picked her up from the Columbus airport myself. I wasn't about to ask Derek for a ride. By the time we pulled out of the parking garage, she already had a yellow legal pad in her lap and a pen in her hand. "Tell me everything," she said, "from the beginning." I told her during the drive. She didn't interrupt. She simply wrote things down. When I finished, she was quiet for a moment, watching the highway. "Has he tried to get you to sign anything recently?" she asked. I thought about it. He brought some papers last November, said it was a new healthcare directive, just updating what I already had. I told him I wanted to read it first, and he said there was no rush. He never brought it back up. Pam wrote something down and underlined it twice. That afternoon, the two of us drove to Columbus to the offices of Whitmore and Associates. The building was a quiet brick townhouse on a tree-lined street. We were met by a man named Gerald Whitmore, who was perhaps 60, with the deliberate, careful manner of someone who weighs words before speaking them. He had clearly been expecting my call. He explained, with a formality that I suspected concealed genuine feeling, that Harold had come to him 8 years before his death, so roughly 18 years ago, with a specific and unusual request. Harold had prepared a sealed letter and left it with the firm along with a standing instruction. The letter was to be mailed to Martha Calloway if any of several specific conditions were met. Among those conditions was this: if any attorney filed paperwork naming Martha Calloway as the subject of a conservatorship or guardianship proceeding, the firm's monitoring service, which tracked public court filings, was to be triggered. 3 weeks ago, exactly such a filing had appeared in the Franklin County Probate Court. My son had already filed for conservatorship over me. I remember the quality of the silence in that room, the clock on the wall. The sound of a truck passing on the street outside, Pam's hand finding mine on the armrest of the chair. "He filed," I said slowly, trying to make it real. "Derek already filed. A petition was filed on behalf of a Derek Calloway," Mr. Whitmore said carefully. "Yes, the petition cites a medical evaluation supporting a finding of cognitive decline." "That evaluation is fabricated," I said. Mr. Whitmore nodded. "That is a matter that would be addressed in the hearing process. However, I would strongly advise you to consult with an elder law attorney immediately, as these proceedings move on a set schedule." He then gave us the file Harold had left, not just the letter, a sealed envelope labeled, "For Martha, if this day comes." I did not open it in the office. I held it in both hands on the way to the car, and I felt very strongly the presence of a man I had been missing for 10 years. Harold had known. Not exactly what would happen, but he had known enough about his son to prepare for the possibility. That knowledge sat in my chest like a stone and like a lamp at the same time. In the car, Pam made 3 phone calls. By the end of the afternoon, we had an appointment for the following morning with an elder law attorney named Sandra Ackafer, whose name had been recommended by 2 separate sources as someone who took fabricated medical claims very seriously. That evening, we sat at the kitchen table, the same table where I had eaten soup alone 2 nights earlier, and I opened Harold's envelope. Inside were 4 handwritten pages. Harold's voice came off them so clearly that I had to stop twice and breathe. He wrote that for several years before his death, he had noticed Derek making financial decisions that troubled him. A pattern of borrowing that was never quite explained, an interest in the house's equity that felt disproportionate, certain comments that Harold described as testing the water. Harold had never confronted him directly. He wrote that he regretted this, but he had made sure the house was protected as completely as the law allowed. The deed had a specific provision, the will was ironclad, and if things had progressed to the point where Martha was receiving this letter, Harold wrote, then the time for hoping he was wrong was over. Near the end he wrote, "You are stronger than you think, you always have been, don't let anyone tell you otherwise." I folded the pages carefully, put them back in the envelope, and pressed it flat against the table. "Mom," Pam said softly. "I'm all right," I said, and the strange thing was that I meant it. The next morning Derek called. He asked how I was in his usual easy tone and mentioned that he might stop by on the weekend. "Carla wants to bring you some of that lemon cake you like." "That would be lovely," I said. I kept my voice exactly as it always was. I gave him nothing. After I hung up, I sat for a moment and recognized what I was feeling. Not the fear that had been with me for days, but something beneath it that had now surfaced. Purpose. Steady, quiet, implacable purpose. They had filed court papers declaring me incompetent. They had fabricated a medical record. They had been planning this for months, perhaps years, inside the house Harold built with his own hands. Now I had a lawyer, I had a witness, I had Harold's letter, and I had evidence in the basement that they did not yet know I had found. The point of no return, I understood, had not been the moment I walked downstairs and saw the whiteboard. It had been the moment Harold decided to trust me with the truth, even from across a decade of death. He had done his part. Now it was mine. Sandra Acaffer was a small, precise woman in her early 50s, with close-cropped hair and reading glasses that she removed and replaced with the rhythm of someone who thought very quickly. She sat across from Pam and me in a conference room that smelled faintly of coffee and paper, and she listened to everything without expression. Then she read the documents I had photographed in the basement. I had done it the previous evening, kneeling on the cold floor with my phone, taking clear pictures of every page. When she finished, she set her glasses down on the table. "Okay," she said. "Here is where you stand." She explained it methodically. The petition Derek had filed was based on the fabricated medical evaluation that named Dr. Paul Strickland of Westerville. The conservatorship, if granted, would give Derek legal control over my finances and the right to make decisions about my living arrangements. The house could be sold. Assets could be managed, meaning accessed, on my behalf. That was the plan, but the plan had weaknesses. A fraudulent medical evaluation was a serious matter, potentially criminal. The timing of the filing, relative to the documents prepared in my basement, created a pattern that a judge would find significant. Harold's letter and the estate attorney's testimony established prior awareness of a threat, and crucially, I had not signed anything. The petition was still pending. The hearing was scheduled in 6 weeks. "What we need to do immediately," Sandra said, "is file a counter-response to the petition." She outlined the steps clearly. We would submit my own medical evaluation from a physician of my choosing. We would request that the court appoint a guardian ad litem, an independent evaluator, rather than relying on the evaluation Derek had submitted. "Can we go after the fabricated evaluation?" Pam asked. "Yes," Sandra said. "But carefully and in sequence. First, we stabilize your mother's position, then we go on offense." We authorized her to proceed that same day. The action we took was not secret. It couldn't be. It was filed with the court. And so, 3 days later, on a Saturday morning, Derek's car was in my driveway before I had finished my second cup of coffee. He came in through the front door as he always had. I had given him a key years ago. Something I was already regretting. Carla was with him. She was carrying the lemon cake as promised. But her face, when she saw mine, shifted in a way that a cake could not cover. Derek sat down at the kitchen table. He set his keys down carefully, as though making sure his hands were visible. "Mom," he said, "we heard from the court. There was a response filed." "Yes," I said. "I think there's been some kind of misunderstanding," he said. His voice was warm and reasonable, the voice I had heard all my life. "I filed that petition because I'm worried about you. That's all this is. I'm worried about you living alone and about some things I've noticed." "Derek," I said quietly, "who is Dr. Paul Strickland?" There was a pause. Small, but I saw it. "He's a doctor I consulted," Derek said. "I have never been a patient of Dr. Paul Strickland," I said. "I have never met him. My primary physician is Dr. Ann Rivers at Millbrook Family Practice, where I have been a patient for 19 years. And she has not observed any cognitive decline. She has, in fact, provided an affidavit to that effect to my attorney. Carla set the cake down on the counter. The plate made a small, sharp sound. Derek's warmth did not entirely collapse, but it reorganized. "Mom," he said slowly, "you hired an attorney?" "I did. Why would you do that? We're family." "Because family members don't fabricate medical records," I said. My voice was steady. I had practiced this, not the exact words, but the quality of the voice. Calm, factual, impossible to dismiss as hysteria. "There are documents in this house that your attorney prepared. There is a whiteboard in my basement with my name on it. There are conservatorship forms with a signature field already formatted under my name. I have photographs of all of it." The silence that followed was different from any silence that had ever been in that kitchen. Carla looked at Derek. Derek looked at me. "You went through my things," he said. "In my house," I replied. Carla spoke then, and this was the moment I understood who had been driving this. Her voice lost its pleasantness entirely. Like a glove turned inside out. "Martha," she said, "you are making a very serious mistake. Derek has been looking out for you because you cannot look out for yourself. And if you fight this, you are going to find yourself in a very difficult position." "Carla," I said calmly, "you are in my house. I am asking you to leave." Derek stood up. He was taller than me, and he knew it. "Mom," he said, "I have spoken to an attorney, and I have filed with the court," I replied. "I have documented everything in the basement. If you would like to discuss this matter further, you may contact Sandra Acaffer at her office in Columbus. Her number is on record." I stood up, walked to the front door, and opened it. "The cake was a nice touch," I said. "Please take it with you." They left. Carla did not take the cake. After I heard the car pull away, I stood at the window and watched the street go quiet again. My heart was beating hard. I will not pretend otherwise, but I had not shaken. I had not cried. I had not, even for a moment, wanted to take it back. Pam came out of the hallway where she had been waiting and hugged me from behind without saying anything. I let her. For the next 4 days, I rested. I worked in the garden. I had Ruth over for tea twice. I let myself sleep past 7, which I almost never do. I had fought the first direct battle, and I had not lost, but I knew as clearly as I knew anything that it was not over. Not even close. The call came on a Wednesday while I was deadheading the roses along the back fence. It was Derek. His voice had reset itself to something softer, a register I recognized from his childhood, the one he used when he had broken something and wanted to be forgiven before the damage was fully assessed. "Mom, I want to apologize," he said. "Carla was out of line. We both have been. Can we talk?" I straightened up and looked at the garden, at the roses Harold had helped me plant, at the fence he had mended 3 times over the years. "We can talk through our attorneys," I said. "Mom, please." "Derek, I love you," I said, because I did and because saying it felt important, like keeping something clean. "But I am not going to have a conversation that isn't on the record." "That's where we are." I hung up and stood in the garden for a while longer. The strange thing was that I felt no temptation, not a flicker of it. Part of me had expected to waver. I was his mother, after all. And the pull of that is not a small thing. But what I kept seeing when I thought of Derek was not my little boy in his baseball uniform. It was the whiteboard, my name at the top, the arrows pointing down from it. He called again the following Friday. This time to let me know, casually, as if it were good news, that he had located a very nice independent living community in Westerville, one he thought I would really enjoy. "It has a beautiful garden and a full activities program," he said. "I just thought you'd want to know it was available." "Thank you," I said, then I hung up. Carla sent a text to my cell phone, which I had not known she had. It said she hoped there were no hard feelings, that everything they had done came from a place of love, and that she knew I would make the right decision for everyone. I showed the text to Pam and to Sandra Acaffer. Sandra said, "Save it." I saved everything. What I had not anticipated, and what turned out to matter enormously, was how many people came forward once word began to move quietly through the circles I was part of. Not because I broadcast what was happening. I was careful and strategic about what I said and to whom, but elder financial abuse is not rare, and people who have seen it recognize the pattern. Ruth, my neighbor, mentioned over tea that her cousin in Akron had gone through something similar 3 years earlier. She offered to connect me. I accepted. Her cousin, a woman named Helen, had fought a similar petition and won. She spoke with me on the phone for nearly an hour, walking me through what the hearing process actually looked and felt like. Sandra had explained the legal structure. Helen explained the human experience of it, which turned out to be just as important. Helen also told me about a local support organization, the Elder Justice Initiative, run out of the Columbus Legal Aid Society. She gave me the name of a woman there, Diane Forsythe. I called her. She came to my house the following Tuesday. Diane sat at my kitchen table, the same table where all the hard things seemed to happen, and she looked through everything I had: the photographs, the court filing, Harold's letter. Sandra's legal response. She read the way people read when they actually intend to help, carefully, deliberately. "This is strong," she said at last. "What Strickland signed that evaluation? I've seen that pattern before. There's a small network of physicians who will sign these things for a fee." She looked up. "Strickland has been flagged before but never formally reported." "Would a formal report help our case?" I asked. "Not directly," she said. "But it establishes a pattern of fraud which supports everything you're arguing about intent." I asked Diane to help me file the complaint against Dr. Paul Strickland. She did. Around that same time, Pam and I had a long conversation about the deed to the house. Harold, it turned out, had been even more careful than I knew. When Gerald Whitmore reviewed the estate documents, he confirmed that Harold had placed the house in a revocable living trust with specific anti-transfer provisions. Without the signatures of both trustees, the property could not be sold or transferred. Harold and I had been the co-trustees. When he died, I became the sole trustee. Derek had no legal standing over the house at all. The conservatorship petition, if granted, would have attempted to override this structure, but it would have been a difficult legal fight even if I had done nothing. Harold had not only loved me, he had protected me, quietly, systematically. For years, the night I understood the full shape of what he had done, I sat at the kitchen table and cried, not from fear, not entirely from grief, but from the feeling of being loved by someone who was gone practically across a decade. Then I dried my face and went back to work. 3 weeks before the court hearing, Derek and Carla came to the house together again. It was a Sunday afternoon, unannounced, which I immediately recognized as deliberate. No appointment. No preparation, no attorney on standby, no Pam in the hallway, just me, alone. I had spent the morning at church. When I heard the knock, I already knew from the instinct I had been sharpening for months that this was not a social visit. I opened the door. They were dressed nicely. Derek held flowers, dahlias, my favorite, though I had never told Carla that. She had done her research. "We just want to talk, Mom," Derek said. "No lawyers, no court filings. Just family." I stepped aside and let them in because you learn more from a conversation than from a closed door. We sat in the living room, the formal one, not the kitchen. I offered nothing to drink. Derek handed me the flowers. I set them on the side table without putting them in water. Carla noticed. She understood that it was intentional. The first 15 minutes were soft. Derek expressed regret. He said he had handled things badly. He said what he wanted above everything was for me to be safe and happy. He spoke about Harold carefully, as though touching something sharp. He said Harold would have wanted the family to stay together, that Harold had always put family first. I listened without expression. Then Carla shifted. Her posture changed slightly. Her voice took on a practiced calm. "Martha," she said, "we just want to be honest with you. The court process is very hard. It takes months, sometimes longer. It's expensive. It's public. It becomes part of the record." She paused. "For someone in your position, the stress alone can be damaging." "Are you suggesting the process will harm me?" I asked. "I'm suggesting it doesn't have to happen at all," she said. "If you were willing to reconsider, to sit down with a mediator instead of going through the courts, we could find something that works for everyone." "What would that look like?" I asked. Derek leaned forward. I saw a flash of eagerness in his eyes. "You wouldn't have to move," he said quickly. "We could set up a simple arrangement, financial oversight just as a safeguard. Carla and I would manage the accounts, make sure the bills are paid, handle house maintenance. You'd be free to live exactly as you do," he smiled. "The house would be protected." "Protected," I repeated. "Of course," he said. "We're your family, Mom." I looked at my son for a long moment and I realized something. The performance was complete. He believed it, or had practiced believing it, for years. I would like you to drop the petition, I said. The shift was immediate. Derek's expression hardened. We can't do that, then we will see each other in court. Carla set her glass down, her voice lost the last trace of warmth. Martha, I'm going to be direct with you. Your daughter will go back to Portland. Your neighbor isn't family. That attorney of yours will cost more than this house is worth. And when the judge sees your file, when he sees the evaluation, when he sees the pattern of what? I asked quietly. The pattern of living alone in my own house, of growing my garden, of going to church, of refusing to sign documents that appeared on my kitchen table while I was out of the room. She fell silent. Then I asked her something unexpected. How did you know dahlias were my favorite flower? Her eyes flickered, just for a moment, but in that moment I saw the truth. She had studied me for years. The way someone studies property before buying it. I'm going to ask you to leave now, I said. For the second time, they left, this time without pretending it was a friendly visit. After they drove away, I stood at the window and watched their car until it turned the corner. Then I called Pam, then Sandra. The fear was still there, but it was doing something useful. It was sharpening me. 3 weeks, I told myself. 3 more weeks? The hearing was on a Tuesday in November in a courtroom on the 4th floor of the Franklin County Courthouse. The room was smaller than I had imagined. Wood paneling, fluorescent lights, the smell of recycled air and old paper. The judge was a woman named the Honorable Patricia Wexler, who looked to be about 60, with silver hair and reading glasses that she used with the same efficient rhythm I had seen in Sandra Ackefer. I decided immediately that I liked her, or at least that she was someone who had heard too much nonsense to tolerate more of it. Pam sat behind me in the gallery. Ruth was there. Helen, my neighbor's cousin from Akron, was there. Diane Forsythe from the Elder Justice Initiative was there. They had come not necessarily to testify, but simply to be present. And I had not fully understood until that morning what it meant to enter a room with people who believed you, when your own son was about to stand in front of a judge and argue that your mind could not be trusted. It meant everything. Derek and Carla were already seated when we arrived. Derek wore a dark suit I had never seen before. Carla wore a gray dress, quiet, serious, designed to convey concern. She had clearly done her research on courtroom presentation. Sandra opened the case. She presented the counter-response. My medical evaluation from Dr. Ann Rivers, 19 years of uninterrupted care, showing no cognitive decline and normal scores on every standardized cognitive assessment. She submitted the photographs of the basement documents. She submitted Harold's letter. She submitted the testimony from Gerald Whitmore confirming the origin and purpose of the sealed letter. She submitted the timeline. Derek's attorney, a man named Philip Graff, opened by framing the petition as an act of loving concern. He spoke about the challenges of aging alone, about the emotional burden adult children face when they believe a parent may be declining. He spoke about Derek's long record of involvement in his mother's life. Judge Wexler listened, without interrupting, without reacting. Then Sandra called her first witness, Dr. Ann Rivers, appearing by video. Dr. Rivers confirmed calmly and clinically that I had no documented cognitive impairment. She explained that I had consistently demonstrated full orientation and decision-making capacity at every appointment. She also stated clearly that she had not been consulted by anyone prior to the filing of the petition. Then Sandra addressed the Strickland evaluation. Graff objected. Sandra was ready. She presented the complaint filed with the Ohio State Medical Board. She presented documentation showing that Strickland's name had already been flagged in 2 prior conservatorship cases in other counties. Then she introduced a declaration from a forensic document examiner. The examiner explained that the medical evaluation contained formatting inconsistencies that suggested it had been prepared using a generic template rather than Strickland's documented practice style. The patient history sections also contained language that did not correspond to any existing medical record. The courtroom grew very quiet, the kind of quiet that happens when everyone realizes something serious is unfolding. Sandra spoke carefully. Your Honor, the evaluation submitted to support this petition was not based on any actual examination of Martha Calloway. It was prepared to support a predetermined conclusion. Graff asked for a recess. Judge Wexler denied the request. Derek was called to testify. At first he appeared composed. I had to acknowledge that. He spoke calmly. He described concerns he claimed to have noticed. Leaving the stove on, forgetting appointments. Repeating stories. None of these claims required documentation. They were simply observations of a concerned son. Then Sandra began the cross-examination. "Mr. Calloway," she said, "when did you first retain Mr. Graff?" Graff objected. "Overruled," Judge Wexler said. "Approximately 14 months ago," Derek answered. "So 14 months before filing this petition," Sandra continued, "you hired an attorney specializing in conservatorship law. I was seeking advice. You hired a conservatorship attorney 14 months before filing a petition based on a cognitive evaluation dated 11 months ago." A pause. "I was being cautious," Derek said. Sandra continued. "Mr. Calloway, is the whiteboard currently located in your mother's basement yours?" Another pause. "I use the basement sometimes," he said. "Does your name appear on the deed to your mother's house?" "No." "Have you been given written permission to store legal documents there?" "It's a family home." Sandra did not move. "Does your name appear on the deed?" "No." "Did your mother know that conservatorship documents were being prepared in her home?" Derek looked at his attorney. Graff could not help him. "I was handling things," Derek said. "Did she know?" "No." The courtroom fell silent. Sandra turned to the judge. "Your Honor, I would like to submit the property deed, which includes the living trust provision established by Harold Calloway to prevent involuntary transfer of the property. The trust requires the signature of the sole trustee, Martha Calloway, for any sale or transfer." She paused. "This petition, even if granted, would not have legally transferred the house. What it would have achieved is control over Martha Calloway's finances and personal decisions." Judge Wexler leaned forward slightly and looked at Derek over her reading glasses. "Mr. Calloway," she said, "were you aware of the trust provision when you filed this petition?" Derek's composure finally cracked, not dramatically, not the way it happens in movies. He simply seemed smaller. "I thought the trust could be renegotiated through a conservatorship," he said. Judge Wexler waited. Derek said nothing more. I sat very still. In that moment I felt something I had been building for months. Not triumph, not satisfaction. Something more like the end of holding your breath for a very long time. Carla sat beside Derek. She had gone completely rigid. She had prepared for many possibilities. But it was clear she had not prepared for the moment when every layer of their plan would fall apart in a courtroom where none of those layers could be rebuilt. Judge Wexler did not issue an immediate ruling. Civil hearings rarely work that way. Sandra had prepared me for that, but the judge's closing remarks were not ambiguous. She stated for the record that the evidence presented raised serious questions about the integrity of the petition. She noted the sequence of events. An attorney hired 14 months before filing, legal documents prepared in the subject's home without her knowledge, a medical evaluation currently under formal review. She concluded that these facts were inconsistent with the claim that the petition was motivated by concern for the well-being of the petitioner's mother. She then made two announcements. First, she was referring the Strickland evaluation to the Franklin County Prosecutor's Office for review. Second, she was appointing an independent guardian ad litem to conduct a formal evaluation of my situation. Then she dismissed the petition. The case was not finished, but the foundation Derek had built his plan on had collapsed in a single morning. When we left the courtroom, Pam squeezed my hand. For the first time in months, I felt the tension inside my chest loosen, not disappear, but loosen. The truth had finally been spoken out loud in a room where it mattered, and once that happens, it becomes very difficult to bury again. Within a week, two things happened that had consequences extending far beyond our family. First, Dr. Paul Strickland was formally suspended by the Ohio State Medical Board, pending an investigation into the validity of 3 conservatorship evaluations he had signed over the previous 2 years. Our case had been the trigger, but we were not the only one. The complaint Diane Forsythe had helped me file opened a door that, it turned out, had a great deal behind it. Second, Philip Graff, Derek's attorney, received a formal inquiry from the Ohio State Bar Association regarding his role in preparing documents that had been stored in a third party's home without that person's knowledge or consent. I learned later through Sandra that Graff cooperated with investigators in a manner that did not benefit his client. For Derek and Carla, the consequences came the way consequences usually do, not all at once, but steadily. The Franklin County Prosecutor's Office reviewed the referral. 3 months after the hearing, criminal charges were filed. Derek was charged with filing a fraudulent petition. Carla was charged with conspiracy, specifically for her role in arranging the Strickland evaluation and coordinating the preparation of the documents stored in my basement. I learned about the charges from Sandra on a Thursday afternoon in February. She called me while I was sitting at the kitchen table. I sat down fully when she told me, not from shock. I had understood for some time where the logic of what they had done was pointing, but from the weight of it, my son was facing criminal charges. That was not a victory I could feel cleanly, and I won't pretend otherwise. I had to sit with it. But I also thought about the people who did not have what I had. People who did not have Harold's letter, people who did not have a daughter who would get on a flight the next morning, people who did not have a neighbor like Ruth's, or an advocate like Diane, or a doctor like Dr. Rivers, people who had signed the documents because they were tired, or frightened, or because they loved their children too much to believe what was happening. I thought about them. And I realized that what Sandra, Diane, Dr. Rivers, Gerald Whitmore, Pam, and I had built together was not just a defense of one woman's home. It was a record, a precedent, a set of steps someone else could follow. Sandra then filed a civil lawsuit against Derek and Carla. The suit included claims for legal fees, emotional distress, damages related to the fraudulent petition, the cost of the independent medical evaluation. Carla's attorney approached Sandra's office about a settlement 3 weeks later. Sandra asked me what I wanted to do. I told her to decline. We went to civil trial in the spring. It lasted 2 days. The jury deliberated for 4 hours. Derek and Carla were found liable on all counts. The damages awarded were substantial, not enough to compensate for the emotional shape of the experience, as Sandra noted, but enough to matter. Derek's legal fees were added to the judgment. The civil ruling had additional consequences. Derek was forced to surrender his real estate license. He had been working in property sales, which, in retrospect, explained certain things. His ability to work in any fiduciary or property-related capacity was severely restricted. I walked out of the courthouse that afternoon with Pam beside me. It was one of those early April days in Ohio when the sun appears unexpectedly between clouds. I stopped on the courthouse steps for a moment. "Mom," Pam asked. "I'm fine," I said. "I'm just taking a moment." Harold had given me the truth. Sandra had given me the law. Pam had gotten on a flight. Ruth had brought tea. Diane had brought experience. Dr. Rivers had told the truth under oath. All of those things had happened in sequence, and none of them alone would have been enough. I walked down the courthouse steps, and this time I did not look back. The first thing I did after everything was finished was restore Harold's workshop. I hired a carpenter from our church group, a retired man named Bill who had known Harold slightly. He took the job, as he said, to set things right. He cleared the basement completely. The binders, the laptop, the whiteboard, all of it had been held as evidence until it was no longer needed. Then it was disposed of properly. Bill rebuilt the space the way it had once been. A workbench, shelves, good lighting. I did not replace Harold's tools. Those had been given away long ago. Instead, I filled the space with my own things: garden planning books, canning equipment. The folding table I had been storing in the garage. Quietly, the workshop became my space, which felt right. That spring I planted a new section of garden along the south fence, where the light was strongest, dahlias, among other things. I reclaimed the word. Pam returned to Portland, but she called every Sunday as she always had. She visited for Thanksgiving, and again for a long week in July. That July visit was different. There was less that needed to be said, which left room for other things: long walks, cooking together, evenings on the porch. She brought her partner, Marcus, who had never visited Millbrook before. I decided quickly that he was a person of genuine quality. We ate well and laughed more than I remembered laughing in years. Ruth and I developed a rhythm of twice-weekly tea, something we had never quite established before, and it turned out Ruth was much funnier than I had realized. Or perhaps I had simply not been paying the right kind of attention. We planted a small herb garden along the fence between our properties, which gave us a reason to be outside together and to argue pleasantly about basil. Diane Forsythe and I stayed in contact. The following autumn, I began volunteering twice a month with the Elder Justice Initiative. I reviewed cases, spoke with people who were at the beginning of what I had gone through, answered questions when I could. It was not what I expected to be doing at 68, but it turned out to be the kind of work that makes a day feel properly weighted. Gerald Whitmore retired that same spring. He sent me a card. I sent him one in return. We had never met before that afternoon in his office, but I think we both felt that we had done something together that mattered. As for Derek and Carla, I will tell you what I know. And I will try to tell it without satisfaction, because satisfaction in another person's suffering, even someone who has wronged you, carries a bitterness I want no part of. Derek entered a plea agreement on the criminal charges. The agreement included a suspended sentence, restitution payments, 3 years of supervised probation, completion of a financial ethics course. He was also prohibited from participating in any fiduciary or property-related work during his probation. His real estate license was not reinstated. Carla chose not to take a plea. Her attorney fought the conspiracy charge. She lost. She was sentenced to 18 months in prison. She served 11. I later learned that she and Derek separated before she was released. 8 months after the civil judgment, Derek called me. It was a Sunday evening. I did not answer. He left a voicemail. I listened to it once, standing in the kitchen. He said he was sorry. His voice sounded like someone who had traveled a very long distance and arrived somewhere cold and empty. I believed that the feeling in his voice was real. Whether it reached the place it needed to reach, whether it was the kind of sorrow that understands rather than the kind that regrets being caught, I could not know. I deleted the voicemail and went back to my book. I did not call him back. Perhaps one day I would, perhaps not. Some things once broken require more than sorrow to rebuild, and I did not rush myself to decide. What I did know was this: I was 68 years old. I lived alone in a house with a good garden, a neighbor who made me laugh, and a daughter who called every Sunday. Twice a month, I sat with people who needed someone to tell them they were not wrong, to trust their instincts. Harold had built our house in 1978, but he had also built something less visible, a chain of protection, a structure of trust, prepared quietly over years, and sent forward through time like a letter. It reached me exactly when I needed it. The dahlias came up beautifully that first year. They always do if you give them enough light. I never expected that a letter from a dead man would be the thing that saved me. But Harold understood something I had forgotten. Sometimes the people who love us most see dangers we refuse to see. If someone close to you begins asking questions about your finances, your home, or your independence, listen to that quiet unease. It is not paranoia, it is information. And if you see someone you love walking into a trap like this, be the person who gets on the flight. Thank you for listening. Harold would be glad you did.